My grandson's wife sued me for a 1.22 meters lake house she claimed I promised her, but the records hidden for decades changed everything in court. My grandson's wife filed a small claims action in September claiming I had verbally promised her a $200,000 lake cottage as a wedding gift, and when I read the filing, I decided I would appear at the hearing myself. Let me tell you how we got there. Let me tell you all of it, because there are parts of this story that matter a great deal, and they are not always the parts people think to ask about. I should start with who I am, and with the cottage and with Helen, because none of the rest of it makes much sense without that foundation. I married Helen in October of 1967. I was 22 years old and had just been discharged from service. My father gave me his Longines watch at the kitchen table the morning I left the base. He pressed it into my hands and told me he hoped I would wear it to every important day for the rest of my life. Gold face, leather band worn even then from his years of wearing it. I have replaced that band twice since. I have not parted with the watch. Helen was 21. We had known each other for 3 years. I had come back with the intention of building something real with my life, and she was part of that intention from the start. We were married at her parents' church, a small ceremony, reception at the house after. I wore the Longines for the first time that day as a civilian. For 7 years, I worked for other people, learning every aspect of the business I eventually intended to run myself. In 1974, I opened a commercial contracting company, small at first, then larger as I earned the reputation that comes from doing work correctly and keeping your records clean. My attorney at the time, Edmund Greer, told me on the first day I sat in his office that the businessmen who survived long enough to matter were the ones who put everything in writing and always knew where it was kept. I have followed that advice for 50 years without exception. Helen and I raised two daughters. We owned 3 properties over the years. The Nelson County cottage was not a business decision. We bought it because Helen wanted it, and that was reason enough. We had been looking for 2 years, maybe a little longer. Helen had a precise idea of what she was after. Water nearby, but not too close. Room for a garden along one of the walls. Morning light from the east so the kitchen would be bright when she made breakfast. She was patient about it in a way I admired, because I have always moved toward decisions quickly, and she was the one who reminded me that when you are buying something you intend to keep, you are not in a hurry. We looked at 14 properties in Nelson County before she walked up the gravel drive of the one we eventually bought and stopped at the top of it. Just stopped without saying anything. The property sat on a gentle rise above the lake. The south wall faced a long, flat stretch of yard running down to a stand of old oaks. The afternoon light was coming off the water and landing on everything as though the day had made a particular effort. I had learned over 22 years of marriage to stand quietly beside Helen when she was working something through, to not add to it, to not crowd it, to let her arrive where she was going at her own pace. She stood there for a long moment. Then she turned to me and said, "Walter, I think this is the best decision we could make. Not the best house, not the best investment, the best decision." She never used a word she did not mean. I signed the papers within the week. I brought the deed home and placed it in a manila folder in the second drawer of my filing cabinet, right where Edmund Greer would have told me to put it. It has been there ever since. That same summer, August of 1989, Helen planted hydrangeas along the south wall. She was out there in the afternoon heat with a trowel and a pair of garden gloves she had owned since before we were married. She had a plan in her head, though she never wrote it down or measured anything. She planted 9 of them, spacing them by feel, the way she did most things in the garden, by judgment and by some quiet sense she had for how things ought to be arranged in the world. I offered to help twice, and she told me both times that she had it handled, with the particular patience that she saved for situations where she believed I would only slow things down. She was probably right. The blooms came in pale blue, her favorite color. They came back every year. They are still there. Every summer I drive up and walk the south wall, and they are exactly as she placed them, 9 of them, thick and healthy, going through their season without needing anything from me but to be left alone. I have not changed a single thing about that property since Helen died. I have maintained it. The paint, the dock boards, the drive in all 4 seasons, but the hydrangeas are where she put them in 1989. The kitchen window still has the hook she mounted in the second summer to hold the curtain back when the morning light came through. The wooden chairs on the porch are the same ones she found at a furniture shop in Staunton in 1994 that she reupholstered herself the following winter on Saturday afternoons with the fabric spread out on the living room floor. That is not stubbornness. That is love of a kind that does not require a more complicated explanation. Derek grew up spending parts of his summers at the cottage, my daughter's eldest child. He was a serious and pleasant boy who learned to fish off the north end of the dock the summer he was 11. He knows the kitchen window sticks in July and you have to lift the frame before it will slide. He knows the base run near the eastern bank before the boat traffic starts. After Helen died, he came up to the cottage with me a handful of times, the two of us sitting in the wooden chairs on the porch in the evenings, watching the lake go dark and not requiring much of the silence, just keeping each other company. I was grateful for those evenings. I thought they meant something that would last. Derek married Jessica in June of 2022. The wedding was at a venue outside Charlottesville, tables set on the lawn, paper lanterns in the trees, a warm evening with a light breeze. Helen would have found it beautiful. She had a feeling for occasions done right. I wore my gray suit and the long jeans. I wore it the day I signed the papers on my first business property in 1978. I wore it the day Helen and I signed the deed on the cottage in 1989. I wore it at Helen's funeral in 2018. It has been present at every significant moment of my adult life, and I see no reason to change that. After the ceremony, I made my way across the lawn to Derek and Jessica. I embraced them both. I offered my wishes for their happiness. I may have said something about the beauty of the evening. I am a polite man, and it was genuinely lovely. What I said, as I recall it, and as a woman named Margaret Holt, who had been standing within arm's reach of me throughout the exchange, would later confirm in a sworn affidavit, was that I hoped they would be very happy together. That was the substance of it. I said nothing about a cottage. I said nothing about property. I made no statement that could, by any reasonable interpretation, be read as a promise to convey real estate worth $1.2 million. I want to be precise about that. It became the center of a legal proceeding, and the difference between what I said and what was later alleged that I said is not a minor point. It is the entire point. That was the first time I knew they had stopped seeing me, not at the wedding itself. That evening I drove home and slept well. I found out what was being planned in pieces, the way you find out about most things when you are older and people speak around you rather than to you. The first sign came about 3 months after the wedding. Catherine, my younger daughter, called on a Tuesday afternoon. She is the straightforward one, the one who will tell me what I need to hear and trust me to handle it without needing the news softened. She told me she had heard something through the extended family, that Jessica had said to someone in the weeks after the wedding that the cottage in Nelson County would be perfect for summers, that it was just a matter of getting Derek to ask Grandpa for it. That is, as nearly as I could reconstruct through Catherine what had been said. I thanked her and told her I appreciated the call. After I hung up, I poured a cup of coffee and stood at the kitchen window. The red maple at the back corner of the yard was still in its September green. I looked at it for a while. I was not angry. Anger is most useful early, when you still need it to make a decision. By the time you're at the kitchen window with your coffee, the situation has already decided what it is. What I was doing was paying attention, noting what I had heard, filing it away with precision, watching to see what came next. I said nothing to anyone. I did not call Derek. I did not bring it up at family dinners. I noted it the way I note anything that matters, and I waited. The old file was not forgotten. It was waiting. The following spring, Derek called me on a Tuesday afternoon. He made easy conversation first, asked how I was getting on, mentioned a fishing trip he was thinking about. Then he asked about the cottage, whether I had been up recently, whether the dock had made it through the winter without trouble. I told him the dock was fine. The property was in good order. I had been up in March to go through the place the way I do every year. Then, after a pause that was one beat too long to be natural, he asked whether I had given any thought to what he called the cottage situation. I remember that phrase exactly. The cottage situation. As though the cottage were a matter awaiting resolution rather than a piece of property I had owned and maintained for more than 30 years and paid property taxes on every year without fail. I told him I gave the cottage the same thought I gave it every year, that it was mine, that it was maintained, that I intended to keep it. I said it plainly and without any heat. He shifted back to pleasantries after a moment, and we finished the call. I set the phone down at the kitchen table and sat with it for a minute. I have spent 50 years in business negotiations. I know the sound of studied casualness. I know the pause that is one beat too long. He had worked himself up to that call over a number of evenings, likely with Jessica's encouragement, possibly after she had given up waiting for him to simply go ahead and do it on his own. The question about the dock had not been about the dock. I had answered the real question. He had nothing left to say, and the call ended the way calls end when there is nothing left to say. I noticed something else, too, looking back on it afterward. He had not asked me to give the cottage to them. He had asked whether I had given any thought to the situation. That is a different kind of ask. It leaves room for interpretation. If I said yes, he could build on it. If I said no, he could report that Grandpa was thinking about it and hadn't decided yet. He had framed the question in a way that gave him something to work with, regardless of how I answered. He was 29 years old and had learned that trick without being taught it, which is how most people learn the tricks they are not proud of. I answered the real question, and he had not pushed further because there was nowhere to push. I said nothing to anyone. I went back to my day. Then September came. A certified envelope arrived on a Saturday morning. The mail carrier knocked because it needed a signature. I signed, brought it to the kitchen table, opened it with a letter knife the way I open all formal correspondence. It was a small claims court filing. Jessica listed as plaintiff, my name listed as defendant. The claim alleged that I had made a verbal promise at the wedding reception to convey the Nelson County property as a gift to her and Derek. The assessed value was stated correctly at $1.2 million. The filing requested either enforcement of the alleged promise or compensation equivalent to that amount. I read it through once from the first line to the last. I set it on the table. I looked out the kitchen window. The maple at the back corner of the yard was just beginning to turn. September light in Virginia in the morning comes in at a low angle through the trees and lands on things slowly, without rush. I sat with it for a few minutes. I did not reach for the phone immediately. There was no emergency. The situation was what it was, and it would be what it was whether I called in the next 5 minutes or the next 5 hours. I thought about Helen. I thought about the afternoon we drove up that gravel drive for the first time, and she stood at the top of it without speaking for a long moment, and then turned to me and told me it was the best decision they could make. I thought about her in the August heat with her trowel and her old garden gloves, spacing the hydrangeas by feel. I thought about the evenings on the porch after she was gone, the two wooden chairs side by side, the lake going dark, Derek and I not saying much. I thought about what it meant that someone I had known for 2 years had filed a court claim against me on the basis of a toast I had made at a wedding. I did not arrive at a satisfying answer to that question. I stopped looking for one. I picked up the phone and called my attorney. I described the filing in 4 sentences. He listened through all 4 without interrupting. Then he asked if I wanted to fight it. I told him I wanted to attend the hearing myself. He paused, just for a moment. Then he said he would be in the gallery. They thought I moved slowly because I was weak. I moved slowly because I was careful. My attorney told me the matter was not legally difficult. Virginia's statute of frauds leaves very little room for interpretation on the question of promises to convey land. The provision requires a written instrument signed by the party making the promise. No such instrument existed. No memorandum, no note, no signature of any kind on any document anywhere. The claim rested entirely on an alleged oral statement made at a wedding reception, the substance of which I denied, and which, even taken at face value exactly as the plaintiff described it, would still not satisfy the statutory requirement for an enforceable promise to convey real property. An oral promise to give land is not a gift. An oral promise to give land is a remark. The case could be resolved on the papers without my presence, but that was not the kind of man I was prepared to be about this. The cottage had been mine and Helen's since 1989. I had been present for every significant thing that had happened with that property. The closing, the first summer, the hydrangeas going in, the mortgage retirement, every repair and every improvement, every return and every season for 35 years. I was not going to miss the hearing, so I prepared. Over several evenings at the kitchen table after dinner, quietly, with a cup of coffee cooling beside me and the filing cabinet open to the second drawer. I said nothing to anyone in the family about what I was gathering or why. Not to Catherine, though she had earned the right to know, not to my other daughter, not to anyone who might mention it to someone who might mention it to Derek. I wanted no conversation about what I had in the folder before I placed the folder on the courtroom table. This is the part of the story that people sometimes find surprising when I tell them, not the legal result. The result was never in doubt to me because I understood the law and I had the documents. What surprises people is the silence. That I spent 6 weeks between reading that filing and walking into that hearing room without telling a single person in my family what I was preparing. But silence is not the same as inaction. I was very busy being quiet. The first item was the deed. The deed to the Nelson County property, dated July 1989, executed and recorded in the county records, showing my name as sole owner with no co-owner, no encumbrances, no liens. 2 clean pages. I had kept it in the same manila folder since the day we signed it at the attorney's office in Lovingston. I pulled the folder from the second drawer, spread the deed on the table, and read it through line by line the way I would read any document I was about to rely on in a proceeding. Not because I expected to find anything different from what I knew was there, but because you do not assume. You read the document. The deed had been in that drawer since the day Helen and I signed it. It was still there. The second item was Virginia Code Section 11-2, the statute of frauds, the provision that governs promises to convey real property. The language is precise. No action shall be brought upon any contract for the sale of real estate or for the lease thereof for more than 1 year, unless the contract or some memorandum or note thereof is in writing and signed by the party to be charged or his authorized agent. I had first been walked through this provision by Edmund Greer in 1978, and I had kept it in mind every time I was involved in any real estate transaction since then. I printed the provision and read it through again anyway, because that is what you do. No writing existed, no memorandum, no note. Nothing of the kind had ever been prepared because nothing of the kind had ever been promised. The third item was the affidavit from Margaret Holt. Margaret had been standing within arm's reach of me at the reception when I spoke with Derek and Jessica after the ceremony. She is a woman in her late 60s, careful and steady, who had known me for 30 years through her friendship with Helen. They had served together on a church committee for many years and remained close until Helen died. Margaret attended Helen's funeral. She attended Derek's wedding. She was standing near me when I spoke with the couple on the lawn, close enough to have heard every word of the exchange. I called Margaret and explained what had been filed. I told her exactly what the claim alleged. I asked whether she remembered the exchange at the wedding and whether she would be willing to provide a sworn statement of what she had heard. She said she remembered it clearly. She did not hesitate. Her affidavit stated that she had been present within arm's reach of Walter during his exchange with Derek and Jessica following the ceremony, that Walter had embraced the couple and expressed his wishes for their happiness and long life together, that no statement had been made by Walter regarding property of any kind, that she had heard the full exchange and could attest completely to its contents. She had the affidavit notarized and returned to me within the week. The fourth item was a 1-page summary of Virginia gift law as it applies to real property. Under Virginia law, a gift of real property requires actual transfer to be complete and enforceable. That transfer must occur through a properly executed and delivered deed of conveyance. An intent to give, however sincere and however strongly held, does not constitute a completed gift if the deed has never been delivered. The gift does not exist in law until the deed exists in fact. No deed had been prepared, no deed had been executed, no deed had been delivered. The property had remained in my name for 35 years because no conveyance had taken place, because no gift had ever been completed, because no promise of that kind had ever been made. 4 items: the deed, the statute of frauds provision, Margaret Holt's affidavit, the summary of Virginia gift law. I placed all 4 in the manila folder and set it on the kitchen table one evening and looked at it in the quiet of the house. It did not look like much. A folder, 4 pieces of paper, the kind of thing you might pass over without a second look. but I knew exactly what was in it and exactly what it said, and I had known for several weeks now that it was everything I needed. Some lessons take a lifetime to learn and one document to teach. The hearing was on a Wednesday morning in October. The maple in the backyard had turned fully by then, red from the crown down to the lowest branches, the leaves moving in a cold October wind. I dressed carefully, the gray suit. I put on the Longinis and clasped it at my left wrist, pressing my thumb against the worn leather band the way I have every morning since my father gave it to me. I thought about him. I thought about the morning he set it in my hands at the kitchen table, the quietness of that morning, how he did not say very much beyond what he needed to say, and how that had always been the right way between us. I straightened my tie in the bathroom mirror. I looked at myself for a moment, a man of 74 in a gray suit with a manila folder on the kitchen table behind me. I thought about what Helen would have said about all of it. She was practical, not theatrical. I think she would have looked at the filing, set it aside, and said, "Walter, you have the deed. Just take the deed and go." And then she would have started making plans for a weekend at the cottage, because that was how she handled things that bothered her. She went to the cottage. I picked up the folder and drove to the courthouse. My attorney was already in the gallery when I arrived. He gave me a brief nod. We had agreed on the arrangement. He would be present to advise if the situation required it, but I would handle the presentation myself. He understood why. He did not argue the point. The hearing room was small, the way small claims rooms always are. Fluorescent lights overhead giving everything a flat and even quality. A short gallery of plastic chairs, a low bench at the front. The kind of room where disputes are resolved cleanly and without ceremony by the weight of documentation rather than the force of argument. That suited me. Jessica was at the plaintiff's table with her attorney. He was a young man, well dressed, suit fitting a little loose through the shoulders. He had a legal pad in front of him and a pen in his hand, and the look of a man who had not yet had cause to read the deed carefully. Derek was not there. I noticed the empty chair beside Jessica before I sat down. He had not come. I am not sure what I expected, but I had not entirely ruled out his presence. I sat at the defense table. I placed the folder in front of me. I folded my hands on top of it. The Longines caught the overhead fluorescent light at my left wrist, a small, warm gleam in the flat brightness of the room. I noticed it. I thought of Helen briefly, the way I always do when I look at that watch. I thought of all the rooms I had sat in over 50 years of work and legal matters, all the tables I had sat across. I was not nervous. A man who has prepared is not nervous. There was nothing left to be nervous about. The judge called the matter and asked the plaintiff to present the claim. Jessica's attorney rose and delivered the allegation. Walter had made a verbal promise at the wedding reception to convey the Nelson County property as a gift. The promise had been witnessed. The couple had relied on it. The property had not been conveyed. The plaintiff sought enforcement or equivalent compensation at the assessed value. The judge asked if the plaintiff had documentation of the promise. The attorney said testimony would be offered and a witness was available. The judge asked if the defense wished to respond. I rose. I gave my name. I stated that I was the defendant and the sole titled owner of the property described in the filing. I said I had 4 items to submit to the court and would like to present them in order. The judge said to proceed. I set the deed on the table and identified it. The deed to the Nelson County property dated July 1989, showing my name as sole owner with no encumbrances. I set the statutory provision behind it, Virginia Code Section 11-2. I set Margaret Holt's affidavit behind that, a sworn statement from the guest who had been standing nearest to me at the reception, attesting to what had and had not been said. I set the gift law summary last. 1 page summarizing the Virginia requirement that a gift of real property must be completed by deed to be enforceable. Then I sat down. The judge read through the documents. He was unhurried about it. The room was quiet in the way a room becomes when a conclusion is being reached. Jessica's attorney looked at the documents from across the room. He did not speak. When the judge finished, he looked up and asked the plaintiff's attorney whether any written promise or gift agreement of any kind had been executed between the parties. The attorney confirmed that none existed. The judge dismissed the claim. He stated the basis plainly. A promise to convey real property is unenforceable in Virginia without a signed, written instrument. No such instrument existed. The property remained titled in the defendant's name by deed. The claim could not be sustained. Jessica's attorney said very little after the judge reviewed the deed. He gathered his papers. That was the end of it. I closed the folder. I put on my coat. I walked out through the gallery, where my attorney came alongside me. We went out through the courthouse doors together into the October air. He shook my hand and said I had handled it as cleanly as it could be handled. I thanked him for coming. We went to our separate cars. I drove home. I stopped at the grocery on the way because I had been meaning to go for 2 days and there was no reason to rush. I put the groceries away. I put the folder back in the second drawer of the filing cabinet next to the deed. Then I made a cup of coffee and stood at the kitchen window. The maple was shedding leaves in the October wind. They lay on the grass below in the morning light, bright red and still. I looked at them for a long time. I thought about calling Catherine. I decided I would, but not right at that moment. The matter was resolved and she would want to know, but it did not need to be said within the hour. I would call her that evening and tell her simply that it had been taken care of, and she would understand, as she usually does, that I did not need to say more than that. I thought about Derek, about what it meant that he had not come, about all the evenings on the porch and all the mornings on the dock, about the gap between the young man I had sat with after Helen died and the man who had not appeared at the courthouse when his wife filed against his grandfather. I turned it over for a while without arriving at anything I found satisfying. Then I stopped. In the weeks after the hearing, I returned to a question that is older than any statute, the question of how it happens. How someone who has known you since they were a child, who has fished with you and sat with you in silence and eaten at your table through every season of their growing up, can look at you in the years of your later life and decide that the correct approach to wanting something of yours is to file papers in a court of law. Not to sit down at the table and ask. Not to say plainly, Grandpa, we would love the cottage someday. Is there any possibility you would consider passing it along to us? Just to file. To hand it to an attorney and sign it and put it in a certified envelope. I do not have a simple answer. I am not certain there is one. I will say this, though. There is something clarifying about being tested by your own family in a way that requires you to respond, not with anger, not with drama, just with the documents you have been keeping for 35 years in a filing cabinet drawer. There is a quiet satisfaction in that, if satisfaction is the right word, right. A quiet confirmation. You spent a lifetime being careful, and the carefulness was not wasted. Every time you read a document before you signed it, every time you filed the original instead of a copy, every time you kept the folder when it would have been easier to throw it away, every one of those small decisions is sitting in that manila folder on the courtroom table, saying everything that needs to be said without requiring a single word from you. I think about what Helen would have made of all of it. She was not naive. She spent 50 years watching people carefully, and she had opinions about most of them. I think she would have been plainer about her feelings than I am, at least in private, at least at the kitchen table where we talked about the things that mattered. She would have said her piece, and then she would have made plans to go up to the cottage. She handled difficult things the way she handled most things in her life, by going somewhere she loved and staying until the difficult thing had the right proportion again. I will go up to the cottage in the spring. I will drive up the gravel drive and walk the south wall to check on the hydrangeas. 9 of them, pale blue, coming back without needing anything from me but to be left as they are. I will check the dock. I will go into the kitchen and lift the window frame a half-inch to move it the way it needs to be moved. I will stand on the porch in the early morning with my coffee and look at the lake the way Helen and I looked at it that first afternoon in 1989. When she stood at the top of the drive and decided without any doubt that this was the best decision they could make. I will not have changed a thing. There's a version of this story where I become bitter, where the fishing summers on the dock go dark in my memory, where I stop thinking of Derek with any warmth at all, where I let this one thing reach backward through the years and alter what it touches. I have refused that version. It does not belong to me, and I do not want it. I still love my grandson. It is a more careful love now. More honest about what it is and what it requires of me, but it is still love. I would still have him at the kitchen table. I would still fish with him off the dock if he came in the old way, without plans, just to be out on the water on an early morning. Whether he comes is not mine to decide. I can only be who I have always been, which is a man who keeps his records, reads his documents, and knows exactly what he owns and what he intends to do with it. That has not changed. That will not change. I am the same man who stood at the top of a gravel drive in Nelson County in 1989 and watched his wife decide. I am the same man who put the deed in the manila folder and the folder in the drawer and kept it there through every year that followed. I have not forgotten any of it, not a word of it. What I know is simple. The cottage is mine. It has been mine for 35 years, on a deed that has never left the second drawer of my filing cabinet. Helen loved that property more than anything else we owned together. She planted 9 hydrangeas along the south wall in the August heat of 1989, spacing them by feel, and called the whole decision the best one they ever made. No one is going to take that from me on the basis of a misremembered remark at a wedding reception. Not while Virginia has a statute of frauds, not while I have a filing cabinet, not while I am a man who still knows where the deed is kept and what it says. And if you are listening to this and thinking of someone you know, someone older, someone who moves at their own pace and speaks with care and keeps records in a drawer that nobody has ever thought to ask about, let me say something to you directly. That person has been paying attention for longer than you know. They have been watching and listening and filing things away since before you understood why any of it mattered. Do not mistake the quiet for absence. Do not mistake the slowness for confusion. And do not mistake the kind word at a wedding for a deed of conveyance. Because in Virginia and most everywhere else, the law is very clear on that point. And so am I. And if stories like this remind you that quiet elders are not helpless, subscribe to my channel for more stories, because sometimes the oldest person in the room remembers the most important truth. My name is Walter. The deed is in the drawer. The hydrangeas will bloom again in the spring. Has someone ever mistaken a kind word from an older person for a legal commitment, and were you in the room when it happened? Leave your story in the comments below. I read everyone.